Welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I'm continuing my Trump immigration series or Trump deportation series uh, so that I can further inform all of the people who are afraid of what's going to happen of essentially what can be done and what are the procedures. Now, I've received in the last 2-3 weeks probably around 100,000 views on my Trump immigration series, and of those, there seems to be a few comments that essentially are. These people are calling me a fear mongerer. They say I'm instilling fear in the community. Um, and obviously there's been lots of great comments as well, but I thought I'd respond to that in that what I'm doing is the exact opposite of fear mongering. In fact, what I'm doing is I am letting you, the people, know what can be done and what are the procedures, and I'm letting you know why you can't just be thrown out of the country and deported. And so i'm I'm informing the public of what the immigration laws are. There's no liberal twist to this, there's no conservative twist to this. It is simply what the laws are. And I am basically opening the light. So, if somebody goes in a dark room and doesn't see anything, they're going to be scared. But if the light's on and they see what's in front of them, they can properly maneuver their way around the room, get to where they need to go, and they won't be afraid. That's what these videos are doing. So I'm a little confused on why those people who say that I'm fear mongering make that particular allegation when, again, it's the exact opposite. So continuing on with the series, we started off with, what the essentially the deportation procedures are, bond hearings, the notice to appear, pleading to the notice to appear, and then if you're found to be removable, stating what the forms of relief are, and then after all of that, okay, that's going to happen when you plead to the allegations in the notice to appear. That's going to be done by the immigration attorney. Um, then that's all done in what's called the master calendar. So you'll know when you walk into court and the courtroom's full of people, and each master calendar maybe takes 5 minutes, 10 minutes, but it's a very important 5 to 10 minutes because that essentially lays the road work for how your hearing's going to go, what you're going to apply for, what packages need to be uh, prepared and submitted. And so from there, what will happen is if you or your attorney denied the actual allegations of removability, next there'll be a contested hearing, at which point the government brings in their documents, you bring in your evidence, and the burden initially to show removability by clear and convincing evidence is on the government. And once they would show that, and once removability would be issued, then you you know, again, state what forms of relief you're going to apply for. And then the next hearing after that will be a filing hearing. So let's say it's adjustment with waivers, and if there's an issue whether you can or can't adjust, your lawyer will prepare a brief on it, whether you're an aggravated felon or not. There's all kinds of legal briefs that can be done and submitted. The waivers of inadmissibility, if you qualify for registry or asylum, whatever it is, that'll be prepared and filed. And then ultimately, there's going to be what's called an individual hearing. And that's when you walk in the courtroom and maybe there's 3 or 4 other parties there. And the individual hearing is essentially another way of saying trial. Okay, that's when the witnesses will come, and that's when the testimony is brought out, and that's when the judge can ask questions if he or she wants, and so forth. And during the trial, that's when all of the facts come out as to whether or not the judge ultimately will grant or deny the particular form of relief. So, it's always very important during the trial to make sure that you get all of the necessary evidence out and that essentially you don't let the judge shut you down. I remember a case where it was an asylum case, and I was trying to bring out facts and trying to question more the witness on a particular issue of asylum, and the judge kept cutting me off and kept essentially saying that that didn't need to be brought in. And ultimately, the judge stopped it altogether. So I put an objection on the record that I felt that the judge was denying due process to the person whom I was representing. And I also noticed that it was about 11:55 when everything was shut down. So, strangely enough, I felt that the judge was doing this, the immigration judge was doing this, so that she could go to her lunch. Okay, it's kind of a sad thing when a judge puts someone's future in their hands and just cuts it short to leave a little early to lunch. So, anyways, I put on the record everything that had occurred, so that when it went up on appeal, which it did, that they would be able to see what happened. So it goes up to this particular case went up to the Board of Immigration Appeals. They basically said judge didn't do anything wrong. So then I did a petition for review to the Ninth Circuit, and it went up there. And sure enough, they agreed with me that the due process rights of the client had been violated, that the judge needed to allow the testimony and the ability for me to question the client to get the points out and so forth. And so they sent it back down to the same judge with instructions to essentially not cut off the testimony and to permit the questioning. So it was quite a nice feeling when I was back there. The judge didn't interrupt a single time and allowed the entire questioning go forward. And ultimately, that person did receive their asylum, and later they applied and got the green card. So, just so you know, um, the trial part I bring this up because the trial part is very important. It is where all of the work that you've done, all the preparation you've done will come out. It's where you bring the expert witnesses. It's where uh, you know make the record if you do need to go and appeal. And you always have to have that in the back of your mind just in case. Um, but if at the end of the trial, sometimes the judge will read the decision right there. Sometimes you'll get it, meaning the attorney will get it in the mail. Sometimes they'll call the attorney back to read the decision. However, it is, if it's approved, if it's granted, then the immigration or the government has the ability to appeal. But sometimes they'll waive appeal. And if they do and you won, then you're in. And you can then apply and get your lawful permanent residence, or you can keep your lawful permanent residence depending what you were on trial for. Okay, so that's sort of a rundown, very quick rundown of how it goes from the master calendar to the contested hearing to the filing to the individual hearing. So the next in the series will deal with appeals. But for now, if you like the video, click like, subscribe. Go ahead and leave your comments. And whether it's for or against, it's fine as long as it doesn't use cuss words uh, every other word, and as long as they are making valid points. Either way, more on the coming videos. Thank you.